So I should focus on the chapter, the last presentation of the day, which concerns latest developments in cross-border healthcare. Now, we should start with some definitions. Do we have a definition of health, or do we have a definition of sickness? Are you healthy or are you sick? I mean, that's also a philosophical question, maybe. We do have the right to health, and we do have the definition of health. If you look at the preamble of Constitution of the World Health Organization, we have a definition of health saying that health is not just an absence of injury or sickness, but a state of complete mental, physical, and social well-being. So if we would say that everything which is not health is a disease, then probably we would be patients most of the time, at least. Some of us may. So we also have the right to health in international law. We have it in the International Covenant on Economic, Social, and Cultural Rights, for instance. We have it similar description in the European Social Charter and so on. We have it also in European Charter of Fundamental Rights of the European Union. But what is the right to health? Who do we sue if we get sick, if we have the right to health? So it's not that kind of a right, of course. It's, the content of that right is the highest attainable standard of health. So it means that complete health is out of our reach, and that it depends on the time and place that we're living in. Now the question is, highest attainable standard of health. We also have standard of health services, for instance. It was more or less harmonized in a decision of Smith-Peerbooms, which was related to coordination, but the court also harmonized, in a sense, medical services, saying it's not enough that you just look at the national circuits, you should look at international state of art. And do we have the highest attainable standard of health within one state, EU, or even internationally? Let me refer to one interesting quote of our Slovenian Supreme Court. He argued, or the judges argued, that you don't just have the right to be treated abroad, you also have the right to be treated at home. It was a situation where a person got injured in Canary Islands, I think, the hip was broken, and they don't treat it, just leave it. It was the same for Spanish nationals and for everybody else. It was equal treatment, no problem. But it was not highest standard. And the court said, yes, you don't just have the right to be treated abroad as a high standard, you also have the right to be treated at home. And then the health insurance had to cover all the travel costs, which was quite a large amount. Now, of course, we have to define social risks of sickness and injury to know when to provide social insurance benefits. Now, the question, which is related also to cross-border healthcare, is according to which member state we do that. Is it a member state of affiliation, member state of treatment? And there are some different outcomes to that question. So, just as an introduction, we have various legal bases for cross-border healthcare. We have, as you know, coordination of social security systems, which is dealt with in regulations. So regulations 3 and 4 from 1958 were already mentioned, then there were 71, 72, and now we have the regulations from 2004 and 2009, which is 883 and 987. Basically, the rules were agreed among the member states, and they're quite simple. If you need treatment in another member state, so if it's urgent or, as it was later developed, necessary care, you can use your European health insurance card, and you should be treated according to the same rules, and the same treatment would be available as the nationals of that or insured persons in the member state of treatment. There is also a possibility if you reside in another member state, there are specific rules. And there are specific rules if you go to another state just for the purpose of receiving healthcare there. So-called planned healthcare. Now, that system was not abolished, but amended, or a parallel system was developed by the Court of Justice of the European Union. You all know the cases of Kohl and Decker. They're also related to Trier, because Mr. Kohl took his daughter to a orthodontist in Trier from Luxembourg. And Mr. Decker bought glasses in Arlon, and they were both in Luxembourg. And as you know, the Luxembourgese system is based on reimbursement of costs. They got back to Luxembourg and they asked for the reimbursement of costs. The Luxembourgese insurance said, okay, but where is your authorization? Where is your prior authorization to go to another country for the purpose of receiving medical benefits there? And they said, we don't have it. That was a clear case for the Luxembourgese insurance, said, okay, you don't have it, you don't get reimbursed. But one of them was a lawyer, I think, and he said, okay, that's good what you say, but it's not the only argument. What about free movement of goods and services? And there were numerous cases after that, Smith-Spearbooms, Miller-Forey, Van Riet, Van Brekel, Stamatelaki, and so on, Keller, Initsan, and so on. And latest Elcino, Petru, and so on. So arguing that health services are services in the internal market, prior authorization is an obstacle to free movement of services, and the main question is, can such authorization be justified or not, objectively justified? And in the case of hospital treatment and very specific treatment, highly advanced and expensive treatment, that could be justified, but not in other cases. So this parallel system was more or less codified in the Directive from 2011, Directive 24. So that was my point made previously. So the European Commission or the European legislator did not do much to develop the policy or the rules of cross-border healthcare. They just more or less codified the decisions of the court. And not every country was voting for that directive. Austria, Poland, Portugal, and Romania were against it, and Slovak Republic abstained in the council when this was passed, this directive was passed. Well, I've read some articles, and they speak about an unwanted baby, a gift, but not really a gift. There was an anecdote of Hungarian king who liked to ask tricky questions, and he said, give me a present, but don't really give me any. And there was a girl bringing him a bird and saying, you know, here is your gift, and then the bird flew away. So not really any. So there are alternative paths to cross-border healthcare. You have the regulations, social security regulations. You have the directive, but you also have national law. So these are all three legal grounds to have access to cross-border healthcare. Now, what are the distinctions and which path to choose? Especially there is one distinction. So distinction is if you go to another member state and you have authorization, I will focus on planned care. If you go to another member state, you have the authorization, your country will cover everything. You go as an insured person and you come back and everything is covered directly by your institution. If you go according to the directive, you go as a purchaser of services and goods to another country. You buy them and then you come back and you ask for reimbursement. And your country should reimburse it according to the prices in your country, not according to the prices you actually paid. Okay, that's one of the main distinctions. So which one to choose and which instrument has priority? Is it regulation or is it a directive? Well, some argue regulation should have priority. It's true, but in the directive you can also read that the patient can choose. So it's not really a priority if a person can choose. And when will the directive be chosen? Especially if you go to private doctor in another country, because you're not allowed to do that under the regulations. You're allowed to do it so under the directive. And then you come back and you're reimbursed. And then you might have a problem if you are not allowed to do that in your own country, to go to a private doctor, non-contracted doctor. Okay, and social security systems in a country are different. And the directive says it should not influence them, but in a way it does influence them. You have social health insurances, which already noticed can operate according to the reimbursement of costs or providing benefits in kind, but you also have national health services, like in UK, which is centralized. You have also in other countries which is more decentralized. Now, according to the Social Security Coordination Regulations, prior authorization is a rule for planned medical treatment in another country. So if you want to go to another country to be treated there, you should have prior authorization. Now, there is an interesting case of I versus Health Service Executive. It's an Irish case. Defining residence and stay. It was a case of Mr. I, who was seriously ill, but he got ill when he was traveling. He was on holiday in Germany, and then he was admitted to the Universitätsklinikum in Düsseldorf and diagnosed serious illnesses, brain damages, brain stroke, bilateral brain stroke, then genetic modifications of blood, and cancer at the end. So quite serious illnesses, and Advocate General was giving an opinion, and then the court decided. So the question was, Mr. I was residing in Germany for many years, many years. So, and the Ireland first issued, at that time it was Form 101, which is now be for urgent treatment, like EHIC, and then the Ireland gave authorization for Mr. I to be treated in Germany. And Mr. I was treated there for 10 years, and then the Ireland said, you know, 10 years you're no longer resident in Ireland after 10 years, and now the Germany should become responsible for your health insurance and health coverage. And then it was about the question of residence, actually, in this case. So can a person be living in one country almost 11 years and not be resident there? What would you say? It depends. Depends on the circumstances of the case. And the court said, yes, one of the circumstances should be animus manendi, so where this person wants to reside. Of course, taking into account objective criteria, like where he was paying taxes. He said, I want to pay taxes in Ireland, although he was not obliged to pay taxes at all. He had family in Ireland. I think he had visited his children once, and he got some small benefit, occupational pension in Ireland. So the court said, you know, this person was compelled to remain in Germany. And Advocate General Wahl even said he was a medical refugee. Refugee is a term used quite often lately. And so at the end of the day, Ireland remained responsible, because Mr. I, after 11 years, was still a resident of Ireland. Quite interesting case, I would say. So prior authorization had to be prolonged in this case. There was another interesting case of Elena Petru, a Romanian case, where Elena Petru was treated in Timișoara for heart disease. A mitral valve should be replaced. He was admitted to a hospital, but the situation in his hospital was disastrous in a sense. So there was no basic medical supply at all. No disinfectants, no painkillers, no other supplies. Beds were lacking, there were too many people in hospitals, and so on. And this was the first question, and she wanted to have treatment abroad. She then went to another country and was treated there, and then asked for reimbursement later on. It was according to the regulations at that time. And it was the first time the court had to evaluate not if person cannot be treated at home in the time normally necessary or in due time, but why a person cannot be treated at home. Okay? And Advocate General Vialon argued that there are two different cases to be distinguished. And one is if such shortage of basic medical supply is just occasional, temporary, local, in one city, not in the entire country. Then, of course, the authorization cannot be denied, and the person should have authorization to be treated in another country if the treatment or equal or equally effective treatment cannot be given in the country of insurance. But if such situation is systemic, so it means structural, generalized, and prolonged, then prior authorization could be denied. You know, in a sense, it was weighing between public interest of the entire country and individual interest of a patient. And the court decision was not following that argument. It was more, to say, politically correct in a sense. It says that regulations do not distinguish why the treatment is not available in the country. If it's not available within the time normally necessary, a person has the right to go to another country and be treated there. And it's for the national court to establish all the circumstances of the case, of course. Now, what is the consequence of such a judgment? And it's also related to austerity measures. In some countries, you have shortages due to the crisis. In some countries, you have it for other reasons. What would be the consequence if also in the country where there is a shortage of basic medical supplies would have to send people to another country? They don't have enough money as it is in their country, and they have to send people to another country. So the consequences might be the reducing the quality of medical benefits, so they provide it in any case, regardless of the quality, or reduce the basket of benefits. So say we just focus on urgent care, and we don't cover anything else. So you don't have the right in your own country, but also not in any other country. So it's quite a difficult question. Well, to show you some numbers, for instance, this is health expenditure, and in Romania you can see it's the lowest health expenditure. Netherlands, Austria, Germany, Denmark spending quite a lot, and Slovenia is somewhere in the middle. And self-declared unmet needs of medical examination, you can see that in Romania, most people, or one of the countries, people are most unsatisfied and they think their medical needs are not met in their country. Might be due to the treatment is too expensive or the waiting lists are too long. Especially in Estonia, it seems that waiting lists are quite long. And it seems that for some reason in Slovenia, everybody is satisfied with their healthcare and meeting their health needs, obviously. Now, that was briefly about coordination. If we focus now to the Patient Mobility Directive, I still like to refer to it as a Patient Mobility Directive. Some refer to it as Patients' Rights Directive, but it's quite a distinction between patients' rights and patient mobility. Because rights, you have material, substantive rights, and you have procedural rights, so where do you access the doctor and so on. So it's only about mobility, I would say. And last year, the operation report was issued by the Commission, so after a certain number of years, after 2 years of implementation, it was issued and some numbers were presented. Well, the Commission in this first report focused on transposition of the directive in the member states. It did not focus so much on the way and on the content of the transposition measures, so whether prior authorization is always justified and so on. That would be in the second step. Then there was a Fresco report on administrative procedures for cross-border healthcare, where there was evaluated in a sense or checked whether the prior authorization procedures are different according to different legal rules. So it means according to the regulations and according to the directive. As already mentioned, according to the regulations, prior authorization is a rule, and according to the directive, prior authorization is an exception. You have to justify it. Okay? And some countries use the same procedures, some don't use it. Some countries did not enact prior authorization for cross-border healthcare according to the directive. There are some other reports and articles issued already in the literature. Now, transposition in some member states, that's an interesting question. Transposition date was 25th of October 2013, and what would you say, how many member states were late in transposing the directive? Out of 28. Already at that time, Croatia joined in July 2013. A number? 26, you know it. 26. 26. Only 2 were in time. I don't know for both of them, but I know one of them is Croatia. Why? Because they joined the European Union on the 1st of July, and they had to transpose all the acquis by that time. Okay, so they did. So in the middle of 2015, it was in July 2015, still 4 infringement procedures were running against member states, but the Commission instigated infringement procedures against all 26 countries. So Slovenia was quite early in transposing it. It was in 5 November 2013. Some countries were later. I know for Spain, for instance, it was in February 2014, and so on. Some other countries were in between. Now, the question is, what if the directive is not transposed in national law in time? What do you do that? What do you do then? Can it be directly applicable? Because you say it can be directly applicable, and prior authorization procedure is quite clear, and cross-border healthcare in this sense is quite clear. Then you have unlimited access to cross-border healthcare in another country, because prior authorization has to be regulated. It's an exception. If you don't regulate an exception, there is no exception. Okay? So, no prior authorization, I would say, in that period between transposition period exposed according to the directive and transposing the directive was required. And there was an interesting decision of, for instance, Slovenian Constitutional Court, and they argued if there are no limits in the law to the right to cross-border healthcare, there are no restrictions, because the law has to regulate the rights and all its limitations. Okay? It was not directly linked to the directive, but it was a similar decision. Now, if you focus to the Patient Mobility Directive and its personal and especially material scope, now, would you say that Patient Mobility Directive applies only to planned care, or does it apply also to necessary care or urgent treatment? That's one of the open questions still, because the Commission argues it applies to all kinds of care. Medical care in another country does not, it's planned or it's unplanned, doesn't matter. But then I ask them, where do you see it in the directive? Because you have recital 11 stating that it should apply to persons who decide to seek healthcare in another country. So if you want to decide to seek healthcare in another country, you have to be sick first. So it means that you are a patient first and then you move. Because with necessary or urgent care, you move first and then there is a need for healthcare. Okay? And some also scholars argue, yes, but you have Article 1, that's what is written here, and that it covers everything. This directive shall apply to the provision of healthcare to patients regardless of how it is organized, delivered, and financed. Now, I still don't see it for urgent care. Because how it is organized, it could be National Health Service, it could be social health insurance. How it is delivered, it could be in kind, it could be reimbursement system, it could be publicly delivered, private healthcare delivery. And how it is financed, it could be social security contributions, it could be tax finance, it could be direct payments. So from that article, I still cannot see it, how it should apply beyond planned healthcare. Okay. Now if we focus on 3 different situations. One is, for instance, if a person comes to your country to be treated and you are the member state of treatment. The other situation is if you go to another country. So your country is the member state of affiliation or member state of insurance. And the third situation is, what if you don't move? What if you stay within the country? So if somebody, for instance, comes to your country, and your country is the member state of treatment, what are the obligations of your country? So the principles of universality, access to good quality care, equity and solidarity should apply. It's no problem. Same quality and same safety standards, I think also it's not a problem. If you come to a doctor, he will not apply different standards if you come from another country. It's clear. But then there is an obligation to provide the same scale of fees for patients from another member state. So the question is, what do you charge the patients from another member state? Because, you know, charges or payments are different. Also in Germany, you know, Krankenkassen, they are in negotiations, they negotiate prices, and these prices are usually lower than the prices for private patients. And the public hospitals can provide treatments to insured persons and private patients as well. And the directive itself, it distinguishes between insured persons and patients. If you look at the definitions, there is a clear definition between insured person, socially insured person, or patient, and patient as such, which could be also a private patient. So which fees would you charge to the patient coming to your country? The lower, the socially insured, negotiated prices, or the higher prices? Would you say the higher prices? Is that tempting? Okay. The Commission argues, no, it should be the lower prices. But how do you know if a person comes as a socially insured person or not? How do you know if a person would claim reimbursement in his or her own country or not? I think, plus, if you say we will charge everybody lower prices who is socially insured and everybody who is from another country, then you end up with only a small group of your own nationals who act as private patients. Okay? So I think it comes to that, how this person acts. If a person acts like a socially insured patient, waits for the treatment if there are waiting times or not. Because if a person can come as a private patient, he can be treated immediately if he pays or she pays. So if he would be wanted to be treated immediately and acts like a private patient, I think you can easily charge them the higher prices, as to everybody else, as to other private patients. So there is no discrimination. Then you have national contact points. It was one of the huge debates among the member states, how they should be organized. Is it enough just to have an internet site, or just a mail, or telephone, or should it be an office, or should it be a flyer, and so on. So the first question was how many persons were aware of national contact points. And you can see some countries here. Germany not doing that well, being more on the less people being aware of that, and UK especially. But you have some countries who are doing quite well. It's Malta, Slovakia, Luxembourg, Croatia, and so on, Hungary, Slovenia. Then you have what is the form of this national contact point. Many member states have emails, offices, and telephones access to that national contact point. Some have only emails and telephones, some only have email. So the less possibilities you give, the less information you will give to the patients. One member state only had email and office. That was rather good, email and an office. In Slovenia, it was said that we have one of the best national contact points. You could look at the website. It's in Slovenian language. It is in English language, some other languages, I think, as well. And you have all the information there. We even issued a flyer. We have quite many people going to other countries. Now, that was member state of treatment, so if a person comes to your country. What if a person, or you would move to another country, and your member state would be member state of affiliation? Member state of affiliation should receive medical follow-up, of course, and all medical records. If further treatment would be necessary, then it's, of course, necessary to have these records. But one of the main obligations is to reimburse the healthcare costs. So if a person moves to another country, comes back, then he or she should be reimbursed for that healthcare costs. Now, it should be up to the level in the member state of affiliation. But now the question is, which tariff, again? Because in some countries, you have different reimbursements. For instance, I think also in Austria, you have Wahlärzte. If you go to a Wahlarzt, you get only 80% of reimbursement. Otherwise, you receive 100%. And it applies in Austria, and it applies also if you move to another country. If you go to another country and you go to the private doctor, and you come back, you will receive 80%. Then you could say it's no discrimination. You do it the same as at home. Although the Commission is not very satisfied with it. They say it should not be that kind of distinction, you should get 100%. It should not exceed actual costs, which is not new in the directive. It was already in the case law of the Court of Justice, the European Union, especially in the El Chino case. But that case is quite particular. If you read the English version, the one last sentence is missing in the operative part. Okay? In other languages, in Bulgarian, in German, in French, Bulgarian was the language of the case, you can read novogраниците на действително направените разходи, which means only to the level of actual costs. Okay? That was already enacted or decided by the court. It was not first enacted in the directive, but don't read only the English version of the judgments or the translation of that judgment. Now, the state is free to reimburse also other costs or higher costs, all costs of treatment in another country, to be not against the European Union law, but also non-medical costs, like transport costs. That was already decided in the case Sereda Herrera some years ago and in Watts. Now, would the provisions of the Treaty on the Functioning of the European Union, as it is now, prohibit or that you don't pay transport costs? That was the question. Do you have to pay transport costs as well? Because it's different. If you're under regulation, costs are paid. If you're under the directive, according to the directive, these costs are not necessarily paid. It's up to the member state. But now, is it under the treaty that you have to provide these costs as well? And now the question is, what do you compare? I think it's not proper to compare the regulations and the directive. You should compare the directive and national legislation. And if national legislation provides for the reimbursement of travel costs, they should be provided also under the directive, non-discrimination. Okay? But now, what are the provisions in the national law? It could be we reimburse it only to the nearest physician, or we reimburse it in the circle of 100 kilometers, for instance. That would be non-discriminatory way. You cannot say we reimburse it for our insured persons and our citizens, but not for others. Okay. Now, member state of affiliation, as we said, can also decide to have a prior authorization for treatment in another member state. Not every treatment, but for hospital treatment, so overnight stay and highly specialized treatment. Prior authorization is an exception, and it has to be justified. It should be necessary and proportionate. And the Commission, in its operational report, already announced it. We did not check it now. It was only whether the directive was transposed or not. But we will check it later, because we assume that prior authorization cannot always be justified. It's not always necessary and proportionate. Okay? Because some countries have decided to have very broad basket of services for which they require prior authorization, like entire primary care. Can that be excluded? I mean, included in prior authorization, that is a question. Now, another question is, what is overnight stay? You would say, it's easy. You stay overnight. It's true. But according to which member state's rules? You know, it could easily be that if your member state of affiliation, I would say it's according to the rules of member state of affiliation, because they have to issue prior authorization. But if they say it's overnight stay, you have prior authorization, you go to a member state of treatment, and it could easily be that you don't have to stay overnight, because the method of treatment is different. So overnight stay, I think it should be judged by the member state of affiliation. Now, what is highly specialized treatment? Some member states just say, you need prior authorization for highly specialized treatment, and don't say what it is. Now, in the second stage of checking by the Commission, that could be challenged, and because you should define what highly specialized treatment is. Now, the other question is, I think 5 or 6 member states have a gatekeeping function of their general practitioner, and according to the directive, certain administrative limitations may remain, may be preserved. Now, gatekeeping means that you cannot go to any physician. You are always required to go to your chosen personal physician, then he refers you to further physicians. It's to prevent doctor hopping, so you cannot jump over the first level of medical care, because if you would do that, it would be much more expensive because specialists are more expensive, and you wouldn't know where to go. If you have chest pain, where do you go? Pulmonologist, cardiologist, infectologist, some other logist, I don't know. So it's quite difficult to assess. So doctor hopping and doctor shopping in that sense should be prevented. I don't think Germany has it. You can freely choose, I think, still any physician, but I know it was advanced that you should have a chosen personal physician in the so-called Hausarztzentrierte Versorgung. Now, the question is, according to cross-border healthcare, in which country from which country can you choose a personal physician? Does it have to be in your own country? Or can you choose it in another country? What if general practitioner in another country is closer to you? You live close to the border, and the physician is just across the street, more or less. Can you choose that person? Many countries say no. You should choose the one who is contracted by your insurance. And the Commission says, not necessarily true. Because you can have administrative limitations, but they should be non-discriminatory. You know, the consequences can be huge. If you have a general practitioner in another country, he or she will refer you to physicians in that country, not in your own country. So it's again public against private interest. And one of the arguments of the Commission is mutual recognition of qualifications. That means a physician is a physician in any country. So they're equally qualified. Okay. There are some other issues that were raised, like some countries require translation of invoices or even sworn translation of invoices, which will of course be solved when once ESI is in operation. I hope, 1919 we heard. The other question was related to telemedicine. So do you have the right to be consulted via electronic means? Well, the question was related to basket of benefits. Is it a benefit in your country? Then you can be. If it's not benefit in your country, then you cannot be. But then the question is it a benefit? Or is it just a method of treatment? You know, if it's method of treatment, then the rules of the country of treatment apply, not the rules of the country of affiliation. Okay, that was the situations when a person comes to your country or a person from your country wants to move to another country. Now, what if the person does not move at all? And the person is limited to the situation in one member state. So, can a reverse discrimination occur? Which means that, for instance, a person is free to go to a private physician, fully private, non-contracted physician to another country, but a person cannot go to a fully private, non-contracted physician in his own country, her own country. So the reverse discrimination is when the legal situation of a person is limited to one member state. And because of that, he's worse off than a person who has moved. Okay? For instance, also if a person has family members in another member state, who is family member is decided by the member state where these family members reside, not where the person is insured. It could be a question of same-sex partners, for instance. In some countries they're not insured, but in some other they may be, on the account of the health insurance of the country who has to pay. Okay, now the question is, we have such a kind of reverse discrimination. Is it against the law? Is it against the EU law or national law? It's debated, because you can also say it's the freedom of choice of better law. You know, if you have a person to who two legal systems can apply, this person can choose a law, like private civil law. You can choose the law which you should apply. So I think it would not be against the EU law, because you should not be worse off if you move, but you can be better off. But could be against national law, national constitutional law. You know, discrimination should be linked to a certain right, like a right to social security, and to certain personal circumstance, like enough means or property. Now, if that would be the case, then it would not be the concern of EU law, but it would be a concern of national law. And what do you do? Do you limit reimbursement for private providers? And you do it the same as you do it for your own country, as well as in another country? So the Austrian example was mentioned. I think Austria is not the only country. I think also Germany does the same. So if you go from abroad, you are being reimbursed 80%, not 100%. So that might be one of the solutions. However, the conclusion is that even if the directive says the directive will not influence national law, it of course does influence also national law. Now to conclude, I think the Court of Justice of the European Union will still play a role, and it still does, relating to the Social Security coordination regulations as well as cross-border healthcare according to the directive and the treaty. Now, the decisions of the court were codified in a sense, but there are still many open questions. And I think in the second phase, that will be checked also by the Commission and other member states. So not just if the directive was implemented, but how was it implemented, and what are the substantive rules. Now, European Commission is obviously, and quite reasonably so, pushing for broad interpretations. So everybody should be charged the lower price, everybody should have full freedom of movement, you should choose your personal physician wherever. But does it really mean equal treatment? Or is it more beneficial for those who do move, who have the knowledge, who have the money to move, to advance the costs, which are not remarkably low, but could be quite high? And there is another question that comes to mind. What is the relation between a directive and a regulation? Do they all have, both instruments have equal legal value, or is it a distinction? It comes to mind also, you have discussed it yesterday, about the cases of Brai, Dano, Alimanovic, Garcia Nieto. So in that case, you could see that the court applied the directive, an exclusion of equal treatment, and just disregarded the Article 4 of the regulations, which is also about equal treatment of special non-contributory cash benefits. So I hope we will not come to the situation where the directive would have prevailed over the regulation. And I think we should also focus on what is the purpose of cross-border healthcare. Not just who has it, how can you apply for cross-border healthcare, but what is the purpose? What do we want to achieve with it? Do we want to have higher quality, higher safety of healthcare? I think these are the real questions, not just if you move and if you don't move and where you can get healthcare. So, thank you.